Hello friends, in the series on the income tax cases, today we will discuss a very important case on section 9 subsection 1 clause 6 which talks about royalty and section 9 subsection 1 clause 7 which talks about for fees for technical services. The name of the case is Springer Customer Centre GmbH versus Joint Commissioner of Income Tax, International Taxation. And this case has been reported in 107 ITR Tribunal, page number 594, and the matter has been decided by Delhi ITAT D bench. And the date of the judgment is 14th October 2022. In the present case, the assessee is a non-resident and the assessee is having the income from two sources which is in dispute in the present case. The first is the assessee has received commission on the sale of books from the associated enterprise. According to the assessee, this income is exempt, and the second source of income was subscription from the third party customers from the sale of online books and journals, and according to assessee, this income is also exempt from tax. When the assessment proceedings were going on, the learned assessing officer said that these both incomes, that is commission on sale of books and subscription from the sale of online books, comes under the definition of royalty according to Article 12 of the Double Taxation Avoidance Agreement between India and Germany, and these both are taxable under section 9 subsection 1 clause C. This was the allegation of the learned assessing officer, so he accordingly made the additions. When the assessee carried this matter to the CIT appeal, CIT appeal came out with a different perception. As far as the subscription from the sale of online books and journal was concerned, CIT appeal upheld the order of the assessing officer as it is. And as far as the commission from the sale of books was concerned from the associated enterprises, the CIT appeal took a altogether different stand and said that this is not royalty which has been described by the assessing officer, but this comes into the definition of fees for technical services under section 9 subsection 1 clause 7, meaning thereby that CIT appeal changed the section in which that amount was taxable. So according to the AO also and according to the CIT appeal also, that amount was taxable. The only difference was that the CIT appeal changed the section in which the amount was taxable. AO was saying that this amount is taxable under section 9 subsection 1 clause C as royalty, but the learned CIT appeal was taxing it under section 9 subsection 1 clause 7 as fees for technical services. The assessee obviously carried away this matter to the ITAT. The ITAT, as far as the subscription from the sale of online books and journal was concerned, said that this is not royalty at all according to section 9 subsection 1 clause 6, and said that the sale of computer software is not royalty because it is an established law now according to various judgments of the various courts. As far as the commission was concerned, that was from the sale of books from the associated enterprises. It was the point of the ITAT that it is not a fees for technical services because the CIT appeal has changed the character and changed the color of the addition, and CIT appeal has said that it is a fees for technical services. So ITAT said that the commission is not fees for technical services as it does not constitute fees for managerial services. For constituting any amount to be fees for technical services, there should be an element of management services. ITAT also said that management services entails an element of management services which is absent in the present case. ITAT further said that provision of support services also does not come into the definition of management services. ITAT said that the hiring of outside services which was done in this case was also not covered under the definition of management services, and consequently this subscription does not come into the definition of fees for technical services. So friends, in both the issues, as far as the commission from sale of books was concerned from the associated enterprises, and as far as the subscription from the sale of online books and journals was concerned, the ITAT gave the decision in favor of the assessee. At the end of this video, once again I am repeating the name of the case. The name of the case is Springer Customer Centre GmbH versus Joint Commissioner of Income Tax International Taxation, and this case has been reported in 107 ITR Tribunal at page number 594. The matter has been decided by Honorable Delhi ITAT D bench, and the date of the judgment is 14th October 2022. Thank you friends.